Welcome to this session. All I'm doing is looking at the grounds of processing. Now, in data protection terms, the 98 Act is what Schedule 2 grounds am I using to process the data and what Schedule 3 grounds I'm going to use if I'm processing sensitive personal data. Yeah, okay? Now remember, if I'm processing sensitive personal data under the 98 Act, I need a Schedule 2 grounds and Schedule 3 grounds. So the question here is, why am I collecting sensitive personal data under the Data Protection Act or under the GDPR, special personal data? And there's one of 6 opportunities. I have the consent of the data subject. It's necessary for a contract with the data subject or a view to entering a contract. It's necessary for a legal obligation other than the contract. Vital interest of the data subject. It's necessary for my functions, which is of course the one you need to look at. So you should be able to identify which function and why it is necessary. And if you can't do that, you can't process. It's as simple as that. If you can't have a ground to processing, you can't processing. Now this sort of analysis has never ever been pushed by the Information Commissioner, because essentially the first data protection principle says basically personal data should be processed fairly, lawfully, and can't be processed unless you have a Schedule 2 and Schedule 3 grounds. So the first thing is in the principle is fairness. So he goes on fairness. Is it fair to do this? Yeah? Whereas the real thing should do, that you should be doing topsy-turvy. You should look at the first principle, the current first principle, and say, have we got a Schedule 2 grounds for the processing? If we've got sensitive personal data, have we also got a Schedule 3 grounds for processing or under the grounds? Yes, we have. Okay, yes, we have. Okay, let's go on to the data protection regime. And this is really why I've actually put, hopefully, this slide up. And this is the way always to deal with the data protection issue, even if it's the current Act, right? First thing, is it personal data? Is the stuff before us personal data? And believe me, there's going to be arguments about that. Yeah, if you've got a photograph, is it personal data? Yeah, a lot depends on how do you identify the individual. Is the other individual identifiable? So let's assume you have personal data. What you then go on to say is, okay, are we the controller? Yeah, and if we're the controller, we have a problem. If we're a processor, it's somebody else's problem. Okay? So notice, logically, get the definitional stuff out the way first. If I'm disclosing to somebody else, right, disclosure is a processing operation. If I'm a controller disclosing to somebody else, I need a ground for that disclosure. And that's somebody else. Is it another controller or is it a processor? If it's a processor, we've got to deal with contractual arrangements. If it's another controller, we're down to data sharing. So all I'm just saying is start with a definitional analysis and know who the various players are and what you're doing. Okay? And then you go on to the question I'm asking is there a lawful basis for the processing? Is there a lawful basis for the processing? Yeah? If there isn't, you can't process. End of argument. If there is a lawful basis, you then go on to the next question, how do we process? And that's the data protection principles. Securely, accurately, fairly, transparently, no longer than necessarily, and things like this, okay? Notice, there's no point doing the how do we process unless you can deal with, is there a basis for the processing? If I went to say, I'm terribly sorry, my lord, I didn't have a lawful basis for the processing, but I did it securely, how does that work? Yeah? So notice, so the data GDPR is not easy, right, okay, but if you start this recipe, let's get the definitional terms and understand it unambiguously, okay? Then we go to the grounds of the processing, yeah, and then the how. Well, I'm not doing the how, but I'm doing the first two, okay? So basically, is the stuff before us personal data? And I mentioned this, the definition of personal data is widened because identification is not necessarily just by the data controller. It could be by other people. So if I post a video of a woman putting a cat into a wheelie bin, am I posting personal data? Now, under the current Data Protection Act, I might be able to do the following argument. I don't know who that woman is. And in fact, I don't want to know who the woman is. Right? I'm just posting it. Yeah, that's the argument under the current Data Protection Act. Now, you could run an argument to say it's not personal data, but the fact that I'm posting it, what do I want to happen? For the woman to be identified by someone else. And that's what makes it personal data. The London Borough of Newham, I shouldn't say this, can you edit that? A London borough that should not be named. Okay, right, okay. Right. They had a very interesting problem. They took a photograph of a woman and put it on a leaflet to hand out. This woman was going into the town hall. And the leaflet had the happy title, Newham and the Fight Against Benefit Fraud. They also put it Newham and the Fight Against HIV. Is that personal data? Obviously, yes. Okay? Yeah? So, more personal data. These things that are fringe. URLs. Amberhawk has the domain name. We share the domain name with Amberhawk Swanson. She's an exotic artiste. Right, 2 years ago, she married a sex doll in Las Vegas. Just really interesting things. And it's very easy to get to the wrong website, and I do it every day. And no, putting aside a joke, okay, right now, the issue is, if somebody's going to a porn website, you'll be blocked. Now, if somebody goes to a porn blog website 5 or 6 times, what will your IT people start thinking? Who is it? So when you ask a question, is a URL personal data in that situation? The answer is? Yeah. Okay. So remember, fringe things, that become personal data. The manual filing systems, I think I mentioned in the session, it needs very careful looking at because the definition of manual filing system has changed. It's not changed from the Data Protection Directive, by the way, just to sort of blame the government for this. Okay. Essentially, when the 98 Act came in, there was a definition of filing system, but member states had to go their own way, could go their own way on how it was implemented. So the UK government decided to implement it in a very, very restrictive way. So for most Europeans, the definition of filing system has not changed. It's us that's having catch-up. But what it means is those filing systems, now most of you here from local authorities, I'll give you an example. Those filing systems that don't have a structure of a relevant filing system, but falls within the structured part of category E, do you know what I'm talking about? No? Yes? No. Okay. So when you have FOI requests, okay, and you have this at the moment in the GDPR, you'll see that unstructured personal data held by a public body is subject to the right of access and correction. So in the UK current data protection regime, if you have personal data in a manual file, but that manual file is not structured to the degree a relevant filing system is structured, that's the standard of the Data Protection Act, it's not caught by the Data Protection Act, but it's caught by the FOI type data protection rules, which is right of access and correction. So those sorts of files that are subject to the right of access and correction that are in a structured filing system become fully subject to the data protection regime. That's all principles, all rights, yeah? Everything, the whole shooting match, and you've got 4 months to sort it out. So manual files need some careful consideration. Definition of controller, processor, recipient, third party, more or less the same. Just checking this, moving. Okay. Now, special personal data, use sensitive personal data. all the items of sensitive personal data in the 98 Act are special personal data in the Data Protection Bill or Act to come, except sexual orientation is added. Now, most people will deal with sexual orientation as sexual life, but if somebody comes out as gay, for example, yeah, sexual orientation. Biometric in the context of identity, which is the one that I think probably might trap you out. Some of your security people would have to look at this. Genetic information. Criminal convictions, which is sensitive personal data at the moment, are no longer sensitive special personal data, but are treated as such. So basically, criminal convictions are not special personal data. I consider them to be, so we say, extra special personal data. Yeah? Okay. Photographs, not systematically sensitive personal data. There's an issue of basically, does a photograph reveal ethnicity? Does a photograph, if a photograph is used in the context of identification, it becomes a biometric. Yeah? And special personal data. So special personal data is widened, okay? Now, why am I mentioning personal data and special personal data? Under the current Data Protection Act, if you have personal data, you need a Schedule 2 grounds, and you've got sensitive personal data, you need an additional ground in Schedule 3 or one of the exemptions. And it's exactly the same in the GDPR. You need an Article 6 ground to process personal data. You need an Article 9 ground as well to process special personal data. And there are additional grounds in Schedule 1 of the bill. Right, okay? Additional grounds in Schedule 1, okay? Now remember, if you're holding criminal convictions data in the context of law enforcement, you don't look at the GDPR regime, you look at the law enforcement regime. So be very careful which context you're doing, okay, in processing these records. Okay, so that's basically what the differences are between special personal data, because special personal data will need an Article 9 ground, or one of the ones, the additional grounds in Schedule 1, and personal data, because special personal data is personal data, all personal data require an Article 6 grounds. So I'm now going to go through all the Article 6 grounds. Okay, right. Now there's only 6 of them, and when you read them, they are very little different from Schedule 2. So I'll just go through Schedule 2. The first one is consent. You have the data subject's consent to the processing. What you'll find is the regulation dictates what consent means. And the reason why it dictates it is to take away what I call gritted teeth consent. Okay, anybody here on Facebook? Oh, okay, how many friends have you got? Can I be your friend? No, sorry, right, okay. Now, right, so you come to me for a job and I say, I'm looking for responsible people. And you say, well, I'm the most responsible person on the planet. I'm the most cooperative person on the planet. So I said, really, really interesting, okay? So, do you do background checks on your employees? Some of them? Do you do background checks? Yep, sometimes, okay. So I say, look, Amberhawk's a very special organisation. We do background checks. Now, my private investigator does background checks for me. So can you friend my private investigator so he can look at your Facebook pages? Not as cooperative as it has, I found. Okay, now, if you were desperate for a job, what would you do?
I'd still say no because I know what's on my Facebook.
That's okay, yeah. Now, get that person's name, we have a look at the Facebook account. I think that's, have you noticed that, okay? But notice, if the person's desperate for a job and agrees, have they consented?
No, it doesn't.
Well, yeah, well, sort of, yeah, okay. You go to an airport. You go through security, now you're presented with the scanner. The choices are not fly or go through the scanner. Come on.
Go for the scanner.
Have you consented to go through the scanner? Police invite you for an interview. Yeah? Yeah, what do you say? I tell you, sorry, Barnsley are playing away this weekend. I'm off. Or do you turn up? Thank you for consenting to come to the station, sir. Has anybody sort of been? Sorry, just checking. Okay, right, shouldn't do that. The camera's on. Right, okay. Yeah? So notice, that's what I mean by gritted teeth consent. And the regulation puts an end to it. Yeah? And we'll see that as we look at consent. The public task, and I'll explain how the public task is widened, okay? And it's been widened so that you can take opportunities and use it, okay? So essentially necessary for your public task or necessary in the public interest. That's what most of your processing is going to be. Now, can I just do a corollary for this? I'm a local authority and I'm processing your personal data and it's not for my public tasks. What are you thinking? Why am I doing it? Yeah? And that message goes out if you're not choosing stuff for your public task. Legitimate interest, I say, cannot be used for public tasks, but it can be used for sort of fringe things that are nothing to do with your public task, HR. Okay? Article 9, if you look at Article 9, almost recovers everything that's in Schedule 3 and a bit more. And of course, thing is, when you get to look at Schedule 1, there's a whole lot of things that are going in Schedule 1. Criminal convictions, as I say, are subject to the restrictions, and you'll find the restrictions in Schedule 1. So the restrictions are in Schedule 1 of the GDPR, okay? Yeah? You need to find them. That's why I said right during the session, if you're processing sensitive personal data, you've got your Schedule 2 grounds, you've got your Schedule 3 grounds at the moment. Where are they in the data protection bill, and what do they look like? Because sometimes they look completely different, okay? But they are there, and you need to find them, okay? You need to find them. The important thing to understand is the lawful basis of the processing is now part of the right to be informed. Yeah? Now, the other thing to remember, before we go into sort of things like consent and stuff like this, okay, is that if it's in the fair processing notice, it's likely to be more challenged. And the other thing to remember, different processing operations can have different purposes and different grounds. So, for example, Amberhawk might use your data for, so say, a training purpose or accounting purpose. We might use your data for a marketing purpose, and we might be required by law to retain your records for a money laundering purpose. Banks often do this, right? Okay? So notice, the collection and the processing accounting purpose is necessary for a contract. The use of marketing is with consent, and the retention is because we're under a legal obligation to process. Yeah, retain the records. All those appear in the transparency notice. Yeah? Different processing operations can have different purposes very easily. Now, if I'm sharing personal data for purpose X, I'm disclosing personal data for purpose X. That needs a ground for the disclosure, and obviously then the question arises, do I need to identify it in the transparency notice? Yeah? Okay, can you see how it's beginning to work out? So notice, can I do it? Yes, I can. And then, of course, how do we do it? Transparently. Okay, and hopefully that's sort of giving you some ideas of what's happening. Now, why don't I like consent for your processing? Okay, well, that's the definition of consent. Data subject consent means a freely given, specific to the circumstances, Unambiguous indication of the data subject's wishes. The Working Party 29 documentation on consent says that opt-in is the way to consent. Opt-out is not consent. Now the reason for why opt-out is not consent is the following. Okay, let's for example there's an opt-in. Here's an opt-in box that I must tick. I must get my pen and tick it. I must move the cursor and tick it. That's the affirmative action. Yeah? If it's an opt-out, I don't do anything. And that's why the Working Party 29 have gone down this route. And if you look at the Commissioner's guidance on consent, it's clearly that opt-in is the direction of travel. So if you're going to use consent, should we say use opt-in? So let's have a look at some of the issues in the GDPR, the legislative issues. What Article 7 says, I think it's Article 7 of the GDPR, yeah, I think it says that the burden of proof, is on the controller to demonstrate consent. So first of all, the burden of proof is, if you can't prove it, you haven't got consent. Straightforward, okay? The controller to demonstrate data subject given consent. Now look at this, to recital 42, to the processing operation. So notice if you have several processing operations requiring consent, the processing has to be the processing operation, so you might need to say multiple consents. I consent to retention, I consent to disclosure, I consent to use. Yeah? Just flagging that up, okay? Moving to the next one. Consent clearly distinguished from other matters. I mean, local authorities, you basically put other stuff on your forms because you have to. The data protection stuff has to be separate. Okay? Any part of a consent declaration which constitutes an infringement of the regulation negates the consent. So I can't ask you to consent to forget about this data protection rubbish. Yeah? Yeah? Can you consent? For example, you might say, I might ask you, will you consent for me holding your date of birth for 20 years? Well, let's say you did consent, but if I didn't need it after 5 months, I'd have to get rid of it. So notice, I can't say, well, you consented to the data, therefore I didn't have to deal with the principles about deletion and retention and that sort of thing, okay? It should be as easy to withdraw consent at any time. It's easy to give consent, to withdraw consent, yeah? And the right to consent has to be identified in the right to be informed. So notice I've got the legal basis. I am processing your personal data with your consent. That's in my transparency notice. I tell you what I'm doing with the data, of course. And then I say, you have the right to withdraw consent at any time. Yeah? And when you withdraw consent, what are you expecting to happen? I'm processing your data and consent. What are you expecting to happen when you withdraw consent? Stop processing. Now notice, who's in charge of the processing then, if I'm relying on consent? The data subject. Who do you want to be in control? Okay? Another reason why consent is some sort of problem. Yeah? Other things, pre-tick boxes are not consent. Virgin trains, please note. Sorry, I think Virgins have corrected it for the record, just in case I'm sued for libel. Right, okay, no, right, okay. Yeah, pre-tick boxes, you've seen these. That's not consent. Why? Because it doesn't take there's no action on the part of the data subject. And the one that basically I think killed it for local authorities is consent if valid is no effective choice. Do you know what? I'm fed up of paying Waltham Forest council tax. I think I'll pay Royal Borough of Windsor's council tax. Have I got a choice? So consent is not really effective. Okay? Just some comments on Article 6, just to make sure you understand how it's changed, okay? Just slightly, okay? If you look at, we say, Schedule 2, you've got consent, and then necessary for a contract, necessary legal obligation, necessary in the vital interest, necessary for the functions of a public body, and then it's necessary in the balance of interests. All of them have got necessary words in it, apart from consent. Okay, now, I'm asking you to consent to me holding your date of birth for 6 months. Yeah? And I don't need it after 1 month. What's that principle, those two principles saying? Get rid. Yes? So notice it's no longer necessary for my purpose. So although when you look at, shall we say, Article 6 or Schedule 2, the word necessary does not link to consent, it gets linked to consent by the two data protection principles here. Necessary for. Now what does necessary mean? Well, necessary links to the Article 8 regime in human rights. Public interference, no public bodies can interfere unless it is necessary for a legal obligation or some sort of statutory function. So necessary links to the Article 8 regime. Now all I'm just saying is all the Schedule 2 grounds and all the Article 6 grounds have this word necessary in, but of course if you're processing with consent, it comes through these two data protection principles. Here's the one that you're going to rely on, I'm just trying to check the time, okay, rely on for your work. Right, okay, your public authority work. The processing is in the public interest or the exercise of the controller's official authority. Now notice the word includes, okay? And this includes, the one you're interested in is C, the exercise of a function conferred on any person by any enactment. So a lot of local authorities do services because there's a Local Authority Act that says you've got to do certain things. So you can see that essentially the grounds for that is exercise the functions conferred on any person by enactment. I now go into the word includes. It's not an exhaustive list. So it could be that you have other things that you do because of the Localism Bill or whatever, Localism Act, things like this, that still could be, should we say, your public tasks. The word includes makes this an open-ended list. So my granny's apple pie is world famous. It contains curry powder and baked beans. Now what else does it contain? It's apple pie. Apple. Pastry. Yeah, eggs. A bit marmalade, yes, okay. He's the marketing manager for my grand's apple pie, putting interesting things in the apple pie. So notice it's a non-exhaustive list. So you could, and things, you could be able to argue that, say, something that's been approved by the council, and the council have powers to approve it, and then you can do it, could fall within these grounds. Although basically, I'd just be very careful to do that. But notice the word includes is open-ended. Yeah? So it could include those things that are not your functions, but are ancillary to your functions. Yeah? I would wait for the Information Commissioner's guidance when you get to this, and there's a battle going on in Parliament because the NGOs want that word includes off. It's too broad. Why is it too broad? Well, in the Digital Economy Act debates about data sharing, one of the NGOs put an amendment to say the processing, any data sharing has to be necessary for the functions of the body doing the sharing. And the government turned around, Minister said, do you know what? That's too restrictive. Yeah? So notice, that sharing that they're anticipating in the Digital Economy Act may not be necessary for the functions, but fit in here. Okay? So notice there's quite a bit of flexibility there. Legitimate interest can't be used for public bodies, but for their public tasks. Now, one of the other reasons why I think a lot of public bodies may be using this balance of interest, but they've slapped the word includes to public tasks, so it might move up from para 6, balance of interest, to para 5, okay? Through that word includes. Right, now, legitimate interest. You can't use it for your public tasks, but you can use it for fringe things. If you're going to use it, there's a number of things you've got to look at. So the first thing is it necessary for the legitimate interest? So basically, you can see what it is. You've got to identify what that legitimate interest is. Then you've got to basically say why it is necessary. And then you've got to look at the legitimate interest of the data subject to see whether that is not infringed. And that's the 3 tests that the Commissioner says, Stacey referred to. Okay? So, legitimate interest. Now, the big difference between the current Data Protection Act and the grounds for processing, and I'm talking about necessary for the functions of a public body, and I'm also this balance of interest. If the data subject objects, the burden on proof will be on the controller to demonstrate why their interest should prevail. Yeah? Now, that's not at the moment in the current data protection regime. The current data protection regime requires the data subject to demonstrate substantial unwarranted damage or distress, or likely substantial unwarranted damage or distress, which is quite a high threshold. Yeah, it's quite a high threshold. The burden of proof will be on you to demonstrate why your interests should prevail. Okay? So just very quickly go through some of the Schedule 3 grounds or the Article 9 grounds. Explicit consent. What's the difference between consent and explicit consent? The information you provide on this form, comma, including your health records, will be used for a marketing purpose. So I'm making it explicit about the use of the health records. Necessary for carrying out an obligation in the field of employment and social security. So often, basically, if the DWP want you to code health records, that'd be necessary for perhaps a legal obligation other than the contract and a legal obligation in employment law. Similarly, for example, if you're vetting against criminal conviction data, criminal records, you're obtaining the criminal records because the barring and whatever it is legislation requires you to do it. You're a legal obligation to collect. It's a legal obligation in contract or employment law. That's what that one is. Necessary to protect the vital interest of the data subject or another data individual. You are bodies subject to the Civil Contingencies Act, and there's an emergency. So where you have procedures, can you anticipate whether or not you need an emergency procedure? This is the vital interest of the data subject, life and death situation, to keep the data subject alive. Give an example. I'm bleeding to the death in the streets of Westminster. They phone up the NHS trust nearby. We need Chris Pounder's blood group, they say. Oh, the data protection officer's away at lunch. Right. Can you get consent? No, he's gone into a coma. Oh dear. He's died. Oh, it's all right then, we can disclose. Right, okay. So, yeah, there's lots of dark humour in data protection, by the way. Just sort of. Right, if you are subject to civil contingency arrangements, there are going to be emergencies, there are going to be, do you need an emergency procedure for disclosure, for use? Basically, you get it out of the way and then do it, okay? Necessary for legitimate activities, we don't need into that one. Manifestly made public by the data subject. Yeah, so if the data subject's made stuff public, well, at first sight you can use it. Okay, somebody comes out as gay. Can your HR people use it? Now remember, you need a Article 6 ground as well. So the choices are consent, necessary for an employment contract. Is it necessary for an employment contract? No. Necessary for a legal obligation? Right. Necessary for the vital interest of the data subject? Necessary for your functions? Necessary knowledge is with interest. Can't use it. So you discover what? You can't use it. Notice what you're saying here. Because it's in the public domain, yes, you might be able to access it, but can you use it for your official functions? You might find an Article 6 barrier. What do you think the Americans would say? It's in the public domain, therefore it's fair game. This is saying because it's in the public domain, it might not be fair game. However, is it reasonable for you to look at somebody's LinkedIn page? You find a recruitment. You know, Chris Pounder comes for a job to you. Is it reasonable for you to look at the internet and see what you think about Chris Pounder?
Yes.
Okay. So, should I know about that?
Yes.
My daughter went on Facebook, just to let you know, and essentially, you know, sort of said, anyway, she was a bit dismissive about the fact that I'd sort of mentioned some data protection and things like this, and she went for a job. Guess what happened? So looked at her, and she came back very, very angry. Right, okay. So what I said was, well, look, if employers are looking at this stuff, why not get them some stuff to find? So I said, why don't you get some friend who posts things like this? I've just met the vicar. He thinks you're the most honest, reliable, punctual, good team player. He's right, okay. So basically, if you go for another job, can you look at the internet about yourself? I'm offering a service where I put nice things out for you. Right, okay. Right. So things like, you know, God, I'm amazed how you solve that differential equation in 10 seconds. Things like this. Right, okay. Yeah. Because it's in the public domain, doesn't it? Necessary for legal claims, substantial public reason, and occupational health. Now, thing is, what you find here is, here are some other stuff. Health and social care, public health, research, substantial public interest, yeah? Equal opportunities, preventing fraud, dishonesty, election political parties. Yeah? That's why I said, because there's a whole raft of these, we're talking about 20 pages of stuff. Can you find out where stuff is? Okay? Can you find out where stuff is? So just we say, concluding comments, special personal data and the personal data definitions are widened. Okay? So the areas where you need an Article 6 ground and an Article 9 ground are widened also. Find them. What you're using now, where is it in the legislation that have? Remember, the right to be informed means that the grounds that you're using is identifiable to the data subject. And I said, if I say to you, this is necessary for a legal obligation, what are you going to say? Which obligation? Okay? So basically, and the final thing I say is that you will have to have a policy towards the processing of special personal data. That's tucked in round about paragraph 30 of Schedule 1. Right at the end, it's the last paragraph. You might need a policy that identifies how you are basically dealing with data protection for special personal data, and some details need to be in your Article 30 register, and I just picked that up by reading the latest version of the bill.